A judgment from the High Court gave a woman 80% and the man 20%. The man bought this house. The woman is saying she bought furniture. So the judges of the Court of Appeal are asking, the cost of buying the land and building the house and the furniture, can the furniture be more than 80%? The judges of the Court of Appeal are saying, you must work hard to show your contribution. A mere marriage certificate does not show contribution. Purchases of small items like furniture, like curtains, like sufurias, compared to buying of the land and construction of the house, the judges equated furniture to be a roughly 20%. Welcome to Court Helicopter Explainer. Today, we are still on the controversial topic about division of matrimonial property. Why are we repeating on this matter? A judgment from the High Court gave a woman 80% and the man 20% of the properties that they acquired together. This man was aggrieved and said, no, Vivian, we must go to the Court of Appeal. This is the case, the civil appeal number E978 of 2024. Justice Inoti, Justice Mwita, and Justice Ongaya, all the judges of the Court of Appeal. What is it? This is a matter. This is an appeal from the judgment and decree of the High Court of Kenya at Nairobi by Justice Chimitei, which was delivered on the 17th September 2024. The man, in paragraph 5, the High Court delivered its judgment on 24th September 2024 and distributed the properties so that the appellant was given 20% of Avenue Park House, 20% of the Tree Lane House, and 50% of Kabando property, while holding that the appellant contribution towards the acquisition of the Funguo House was insignificant and made no order regarding its distribution. So, in one property, the husband was given 20%, in another property 20%, in another property 50%. Paragraph 6, the man was dissatisfied and he filed a memorandum of appeal at the Court of Appeal. What was the issue? How did the Court of Appeal find it? In paragraph 21, the judges said, we have considered and reevaluated the evidence on record to make our independent conclusions on that evidence. The evidence of record shows that the respondent acquired the Funguo House through a loan from her employer, had it registered in her name, and she repaid the loan, although it was acquired during the marriage. The wife took a loan from her employer and repaid that loan and registered that house in her name. 2. The appellant's claim that he contributed towards the acquisition of this house was disputed by the respondent. The house was later sold and the proceeds used to pay fees, and the balance was used as a deposit for the purchase of the Tree Lane House, which was registered in the name of the woman and one of their children, which was charged to a bank. The High Court concluded that both parties contributed towards this acquisition, while in the case of Avenue Park House, the High Court held that it was jointly acquired through proceeds from a family company that they had. In paragraph 42, Although the property is registered in joint names, the undenied fact is that the appellant, that is the man, purchased the house through a loan which he serviced through his salary. The family resided in the house, and they still do. The wife maintained that she purchased some items for the house, including furniture, Taking into account the evidence on record regarding the acquisition of the property and the wife's level of contribution, we, the three judges of the Court of Appeal, are inclined to agree with the man that the High Court fell into error with respect to the level of apportionment in distributing this property. The lady's contribution towards improving the property, such as purchasing furniture and any other undertakings, would not on their own justify the High Court giving her 80%. So the judges are saying the man bought this house. The woman is saying she bought furniture. So the judges of the Court of Appeal are asking, the cost of buying the land and building the house and the furniture, can the furniture be more than 80%? That's the question the Court of Appeal judges are asking. Do the furniture in the house make more value than the house itself, the structure itself? The judges did not agree. The judges went to the Supreme Court and said, a Supreme Court says a spouse does not acquire any beneficial interest in matrimonial property by fact of being married only, and that specific contribution has to be ascertained to entitle such a spouse to a specific share of the property. You do not get property because you are a wife. A marriage certificate does not give you the property. The killer punch comes in paragraph 45. Insofar as the Avenue Park house is concerned, and based on the basis of the evidence on record, the High Court did not justify its decision to give the appellant 20% of her property he purchased and serviced the loan, while the respondent got 80% thereof, even though her ascertainable direct and indirect contribution were not shown to be more than the appellant's contribution. Having evaluated the evidence and analyzed it ourselves, we come to the conclusion that the High Court erred in distributing Avenue Park House as it did, which was not supported by evidence on record. The High Court failed to apply the principle of fairness based on the ascertainable contribution by each spouse. Consequently, the appeal partially succeeds, and they make the following orders. The distribution in relation to Avenue Park Phase 2, house number 43, is hereby set aside. In place, therefore, the appellant, that is the husband, former husband, shall get 80%, while the respondent shall get 20%. This is judgment dated 31st day of July 2026. What are the lessons in this matter? The lessons in this matter is that the judges of the Court of Appeal are saying, you must work hard to show your contribution. A mere marriage certificate does not show contribution. Purchases of small items like furniture, like curtains, like sufurias, compared to buying of the land and construction of the house, the judges equated furniture to be a roughly 20%. If now you are going to talk that you have done gardening, you have put curtains, you have done furniture, you are likely to get 20%. But if somebody has built the house, the Courts of Appeal have now said the man got 80%. It is not good for the music for Our Lady clients. It's not good for Our Lady customers. Court Helicopter is not gender discriminative. We bring to you the law as it is. We thank our crew, Vivian, who went to look for this from the registry of the Court of Appeal. She has brought it and we have brought it to you. Keep watching as we bring that. Thank you.